This is not a good case. This is not a good news at all. In fact, this is bad news for continuance purposes. When we are in a removal proceedings, sometimes we have to postpone the individual hearing. We have to postpone the actual hearing because the respondent, which is our client, has now found a way to either adjust status or they have a new form of relief. They're eligible for something else that was not previously raised during those master hearings. But if we have something good, even prior to the individual hearing, we can ask the court to postpone the case and to allow us to come up with our solid defense, or to allow USCIS to adjudicate the petition that is pending with USCIS. For example, let's say the person gets married after the master hearing took place. So at that point, we file I-130 with USCIS and we go back to court. If the individual hearing is already set, then we tell the court, can you please allow USCIS to adjudicate this petition so that we can come back to either adjust status in court or with USCIS. Can you actually postpone the case? Can you continue this case? And the court, for good cause, they will do it. But now, with this decision, the BIA is saying that the court cannot do it. An immigration judge cannot continue an individual hearing based on a respondent's speculative assertion that they're eligible for a new form of relief that wasn't previously raised. In other words, if you went to a master hearing and you into your pleadings, you already told the court that this is what I'm gonna be defending. For example, you already told the court I'm gonna be defending asylum, and later on, right after, and then prior to the individual hearing, which is the merit hearing before the actual trial, and you come and you want to change the type of defense that you want to do, and because of it you're trying to ask for more time so you can prepare yourself, the judge is saying that you cannot do that because now you're just speculating. Okay, this is just pure speculation. Why you never raised this type of relief before? We can't just do that. This is bad for a lot of people. I mean, an argument can be made, but this is really like the standard now. You can just come and continue the case because now you have a new form of relief. But of course, we can find a way to make exceptions, but this is really bad because this is like the standard. And this is a case where this person, he's in the removal proceedings and they already entered the pleadings, and prior to the individual hearing, they're trying to ask the immigration judge to actually continue their case so that they can file for cancellation of removal because they became eligible for cancellation of removal. The department, DHS, the Department of Homeland Security, is saying, no. This person has never actually told us before that they wanted to apply for cancellation of removal. As a matter of fact, they never even filed their motion to continue the case with evidence that this person is in fact eligible for cancellation of removal. They could have shown us the application of cancellation of removal that they're trying to file. They didn't show that. They didn't even show that the person in question is married to a U.S. citizen and that the removal would cause extreme hardship to the U.S. citizen. They didn't show nothing of that sort, and now they just want to postpone because they feel like they're eligible for cancellation of removal without any proof whatsoever. This is just purely speculation. Not to mention, they never raised this defense from the beginning. We cannot continue the case, and they went and appealed because the judge granted the continuance, but they went and appealed to the BIA, and the BIA agreed with them. The BIA sustained the appeal, remanded the case back to the court for further adjudication. So basically, the BIA agrees that you cannot come when you already told us that you're gonna defend this type of relief, and now prior to the individual hearing you want to change because you are eligible for this type of relief. As a matter of fact, you didn't even introduce any other evidence to show that you're actually eligible, and now you want to change. This is speculation. We can't do that. This is the ruling now, and this is the standard now. You can't just continue the case just because you have found a new form of relief after the master hearing, prior to the individual hearing. It's not going to happen like that. This is really bad because back in the days we used to really do it like that, because sometimes people become eligible after, and sometimes you need more time to gather evidence to show that eligibility. But the BIA is saying, no, we can't do that. So, I mean, I will argue that that will be case by case basis, but this is the standard, and that's really bad news. It's not good news at all. And now they continue to get it. It's really hard. But if you get it, you get it. Right? So follow us for more news. I'm going to talk about another news, but at least that one will be great. But until next time, bye-bye.